you want to plead to the charge that you committed contempt of court by failing to appear at your violation of probation summons on March 13, 2024? Sorry, I'm having a hard time hearing you. Can you speak up?
Guilty.
And how do you want to plead to the charge that you violated your probation by failing to appear for recovery court on February 22nd, 2024, and failing to report to your probation officer on February 27, 2024?
Guilty.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained.
Yeah.
Has anyone threatened you in any way in order to get you to plead guilty?
Wow.
Has anyone promised anything in order to get you to plead guilty?
No.
If I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty today?
Yes.
You were placed on probation in this case back in October of 2023. Is that right?
Yes.
And the file contains an order of probation that has a signature on it. It looks like your signature. Did you sign that?
Yes.
And one of the terms of your probation was that you report as instructed to your probation officer. Is that right?
Yes.
And another term of your probation was that you complete all the requirements of the Lenawee County Drug Court program. Is that also correct?
Yeah.
And did you fail to report to drug court on February 22nd, 2024?
Yes.
And did you fail to report to your probation officer on February 27, 2024?
Yes.
All right, I will accept the plea. Pleas, they've been given understandably, voluntarily, and accurately. Ms. Beam has had full knowledge of her rights, and she's had competent counsel. I will refer this matter to the probation department for an update of your pre-sentence investigation. And I will set sentencing for April 12th at 8:15 a.m. All right, Ms. Beam, you can let the officer that is, you know that you are done with court for today.
Thank you.
All right, the gentleman at the jail, you are Michael Sepulveda?
Yes, sir. Yes, Your Honor.
Okay. So we are on the record in file 23-21462-FC, People versus Michael Sepulveda. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
Good morning, Judge. May it please the court. My name is Richmond Riggs, P33863. I am an Assistant Attorney General. I appear on behalf of the people of the state of Michigan in this matter. Also, Judge, I would like the record to reflect if Ms. Rosa would also put her appearance on the record as well as my co-counsel.
All right,
Thank
ahead,
you.
Ms.
Jennifer Rosa on behalf of the Michigan. Jennifer Rosa on behalf of the Michigan Department of Attorney General. My P number is 58226. Thank you, Your Honor.
Thank you. And Mr. Daly?
James Daly on behalf of the defendant charge.
Okay. And where do we stand with this case today?
Your Honor, it's my understanding that this matter has been resolved. Mr. Sepulveda is ready to enter a plea in regards to that resolution, but I believe there's still some documentation that the Attorney General's office needs to prepare for us to take the plea.
Okay, is that accurate, Mr. Riggs?
We're certainly moving in that direction, Judge. I don't, the defendant, as part of our negotiations, gave a proffer to the police, some 4 hours worth of interview. My superiors want to see that proffer statement before a final decision is made. Mr. Daly and I have met numerous times, and we've sort of hammered out, I think, where we're going to end up. But to be candid, my superiors are the ones that are going to make that final decision. That proffer statement is being prepared, and I'm told will be available probably mid-April. I then have to submit it along with a memorandum to my superiors to get their approval for our final resolution. But we are moving in that direction, but we aren't there quite yet, Judge.
Okay, and so you said so mid-April. So if we were to set another pretrial for mid-May, do you think that is a sufficient amount of time?
Judge, normally, yes, that would be enough time. But in this case, because this is going to go all the way to the top, what I was going to request was a 60-day, give me 60 days so that I can be absolutely sure that I can mesh with everybody's schedules, which I would request on June 12th. That's a Wednesday. It's my understanding the court schedules pretrials on Wednesdays. Is that right?
Yes, it is.
Okay. Judge, if I could ask that we could have that pretrial on June 12th, I am confident that would be enough time that we would be able to have an answer for Mr. Daly as to the resolution of his client's matter.
Okay, Mr. Daly, is that agreeable with you?
It is, Your Honor.
Okay. So we'll set this for a pretrial on June 12th at 8:15 a.m. Mr. Riggs, could your office do a stipulation in order for that adjournment?
Absolutely. We will do that, Judge.
All right. Is there anything else we need to address with this case today?
Not on this particular matter, Judge.
No, Your Honor.
All right. Thank you then, Mr. Sepulveda. You can let the officer that's with you know that you're done with court for today.
Thank you, Your Honor.
Thank you. Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. McClinton?
Yes, Your Honor.
All right, Mr. McClinton, can you hear me?
Yes, I can hear you.
Okay, we are on the record then in file 24-21724-FH, People versus Vincent DeAndre McClinton. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. McClinton.
Okay, and Mr. Dagger Margosian, where do we stand with Mr. McClinton's case today?
Your Honor, Mr. McClinton is currently doing the ECU program. He's compliant and up to date on it. He's made one payment. I believe that he has 2 more. I'm asking the court to adjourn this case for 6 to 8 weeks for those payments to happen.
Okay, Ms. McClure, anything to address from the people's side?
No, I would agree. He's been on time with his payments and has his diversion fee already paid. So just finishing out that balance.
Okay, and I'm sorry, Mr. Dagger Margosian, did you say how long you were looking for?
6 to 8 weeks, ideally, probably 8 weeks. I think it would be taken care of by then.
Okay, 8 weeks would be May 29th. So let's go with May 29th at 8:15.
Thank you, Your Honor.
Okay, Mr. Dagger Margosian, would you do that stipulation in order to adjourn?
Yes, Your Honor.
Okay. So, Mr. McClinton, your next date is May 29th at 8:15. You'll log in using all the same Zoom information that you used to log in this morning.
Okay.
All right, you are all set then. You can go ahead and log out.
All right. Thank you.
Okay, Mr. Daly, you have Mason Lindeman.
Yes, Your Honor.
I believe I have him here. Are you going to need a breakout session with him?
No, Your Honor.
And Mr. Glazier, I have Allison Scholes logged in. Do you need a breakout session with her?
I don't believe I have Allison. Is it Shoal? At least not that I know of.
Scholes, S-H-O-L-E-S.
It's on my sheet, Mike.
It's MDD, but it's in one of these things.
No, yeah, Your Honor, hold on. I need to get the, is she in court or is she on Zoom?
She's on Zoom.
Yeah, you can put me in a room with her. I didn't know I had her.
Okay, and the gentleman at the Channer Road facility, you are Mason Lindeman, correct?
Yes.
Okay. All right, we are on the record in file 22-20750-FH, People versus Mason Bradley Lindeman. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
E.B. McClure on behalf of the people.
James Daly on behalf of the defendant, Your Honor.
All right, and Mr. Daly, where do we stand with Mr. Lindeman's case today?
Yeah, Mr. Lindeman is finishing up a sentence right now at the Jackson County Jail. He'll be transported to Lenawee County, I believe, shortly after that. I had an opportunity to discuss this matter with Mr. Lindeman. At this time, on the violation of probation charge, we need to set that for a hearing in the future because he still has the criminal charges here to deal with. In addition to that, there are some additional forensic reports, which I've talked to Ms. McClure about. And I don't exactly know how we're going to handle the forensic reports. I just received this case and we're trying to get it unraveled right now. But I can tell the court that we're ready to set, as it stands right day, after talking to Mr. Lindeman, a trial date on this matter. The only question is whether or not Mr. Lindeman's going to have to go back for another competency hearing. And I don't think that's going to be necessary.
All right, Ms. McClure, anything to address from the people's side?
Yes, Judge. Just that Mr. Lindeman doesn't have a violation of probation through Lenawee County. It's a violation of bond conditions on this case and contempt of courts on this case. That being said, his sentence is up, I believe, on Friday in Jackson County, where he does have 2 outstanding warrants here in Lenawee County while he was absconded on this case. 2 new cases that were charged for absconding as well as possession of methamphetamine. So he's going to be transferred here for that. As it relates to this case, I know Mr. Lindeman has never gotten his tether put on and never been in compliance with that. He obviously has failed to appear multiple times in front of Your Honor and caused a long delay in this case, and a long delay in getting this case set for trial. So that being said, I would ask that there be no bond set on this case, that bond be revoked, and that we do get a trial date set. As for the forensic issue, he's been evaluated by our forensic center and found both competent and criminally responsible. I indicated to his prior counsel as well as to Mr. Daly that if they do wish to evaluate his criminal responsibility to pursue a legal insanity defense, that they were going to have to do that independently, which is something I think his prior counsel was attempting to do but did not have any success with. So that being said, I would just ask that this be expediently set for trial. I know the victims and their families in this case has been very patient, and we're all kind of at the end of our rope with Mr. Lindeman. So just on the family's behalf, as well as on the state's behalf, we would ask that this be set for trial quickly and that he not be given any sort of bond on this case.
Your Honor, I agree with Mrs. McClure about her recitation of the facts in this case. I'm right now ready to set this matter for a jury trial. It's been a long time. The other issues I think I can get resolved before trial, but I don't see any possible way that there's going to be a resolution short of a jury trial in regards to this matter.
All right, how long do you think you will need for a trial?
I would think if we had 2 full days, I'm sure we could get it done in 2 days, I would think.
I would agree with that.
Okay, so Sierra, it looks like we need 2 full days for a jury trial in this case.
We could back it up to Levi Scroggins on April 23rd and 24th.
I'd rather it not be a backup, especially to Levi, because I imagine Levi's going to have to go forward. His case was already, I believe, a mistrial, that this was pushed out. So I would rather this be a primary.
The first 2-day period that we have for a primary trial is in the end of September. If that's acceptable, I can look for the specific dates.
I'll do whatever the court wants to do. I'd take a backup trial to Scroggins. There's a chance that's going to fall through, but if it's too quick for the prosecutor's office, I understand that too.
I don't think there's much of a chance of that falling out. We started to try that case once and had a mistrial, so I would expect it to be tried again.
So I do have Chad Bordner set for trial May 2nd and 3rd. I was wondering if, because he's in custody and this is an older case, if this case could be set then and be primary on that day and Chad be the backup, because I've spoken with Mr. Murphy and I think we may get Mr. Bordner resolved. I don't know if that's
there's actually already a primary set that day that is not Mr. Bordner. It is
Gotcha.
Mr. Soto.
Okay.
So we are looking at Tuesday, September 10th and Wednesday, September 11th.
Those dates work for me.
They work for me as well.
Mr. Daly,
That date works for me.
I just wanted to let you know that his current sentence is for a violation of probation in Jackson. So when he's done serving this, he'll be off of circuit court probation.
Yeah, we knew that his violations here are for bond conditions.
All right, so let's set it for a final pretrial on September 4th at 8:15. And then trial on September 10th and 11th.
Those dates are fine for me, Judge.
All right, the court will issue a scheduling order. I do at this point think that based on the history of this case and Mr. Lindeman failing to drug screen as instructed with Mr. Coase is the current alleged contempt in this case, as well as the fact that Mr. Mawad, his previous attorney, has had to withdraw, as well as the fact that he has apparently new charges coming. I do think it's appropriate in that the evidence in the file establishes that it's necessary in order to ensure his presence at scheduled trial and pretrial in this case, and also to protect the public, that I revoke Mr. Lindeman's bond until the trial so that we're sure we can get that accomplished. So that's what I'm going to do.
Thank you, Judge.
All right. Is there anything else we need to address with this case today?
I have nothing, Your Honor.
Nothing, thank you.
All right, Mr. Lindeman, you can let the officer that's with you know that you are done with court for today.
Thank you.
Okay, Mr. Amadeo, I do believe we have Richard Sepulveda here now. I'm just bringing him in.
Thank you, Judge.
Are you going to need a breakout session with him?
No, Your Honor. I will actually go see him in person this weekend, and he knows what's going on. Thank you, though.
I'm just waiting for them to get the audio connected.
Thanks, Judge.
Okay, good morning, sir. You're Mr. Sepulveda?
Yes, Your Honor.
Okay. We are on the record now in file 23-21463-FC, People versus Ricardo Sepulveda. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Riggs.
Good morning, Judge. May it please the court. My name is Richmond Riggs, P33863. I'm an assistant attorney general. I appear on behalf of the people of the state of Michigan.
And Ms. Rosa.
Jennifer Rosa, on behalf of the people of the state of Michigan. My P number is 58226.
And Mr. Amadeo.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Richard Sepulveda. We both appear via Zoom, waiving the right to be present in person. Richard does appear from the Washtenaw County Jail, waives that right. Rick, please state your name first. Judge, we'll save her to know it's you.
Ricardo Valdez Sepulveda.
All right, and Mr. Amadeo, where do we stand with Mr. Sepulveda's case today?
Your Honor, from what I understand, being in on the earlier hearing from Michael, his brother, it is my understanding that the Attorney General is trying to reach a resolution with Michael, and he proffered for 4 hours. I have been in touch with AAG Riggs about further discovery if that does transpire and the proffer. As far as I understand, I don't want to speak for the Attorney General. I do believe that the co-defendant is going to plea. His plea potentially could be June 12th based on the earlier hearing. I would ask for a pretrial of June 12th for my client so we could track this case. I will prepare a stip in order if that's acceptable to everybody and that date works, Judge.
Okay, Mr. Riggs, anything to address from the people's side?
Judge, I think Mr. Amadeo's suggestion is a good one, and we would concur that his matter should track with Michael Sepulveda's. So we would ask that it be set for June 12th as well. Judge, there is one other matter regarding discovery I wanted to bring up when you have a moment.
Okay, so we'll set it for a pretrial on June 12th. Mr. Amadeo, if you would prepare that stipulation in order, I'll sign that when it's received. And then
Yes, sir.
Mr. Ridge, what is the discovery issue that we need to address?
Judge, Mr. Amadeo and I have been in discussions, a number of discovery issues, as well as some other issues we have had with previously provided discovery. And Mr. Amadeo has indicated some of the video discovery that's been provided was defective. It didn't, he was not able to play. I would ask if Mr. Amadeo, if you could let us know, was there a particular track or tracks or statements that weren't functioning? I will have my staff recode and resubmit those to Mr. Amadeo and see if we can clear up those technical glitches in the interim.
And to be clear, Your Honor, the Attorney General did properly hand over the discovery requested so far. There were some audio issues, and I could list them for AAG Riggs so we could try to clear that up. But there's been no discovery violation. It's just certain videos had audio issues. I just want to, if we're going to trial, I just want to be as diligent as possible, obviously.
Sure. Is that something you want to do now, or is that something you want to do offline?
I could do it offline, Judge. I'll take the court's time up. I could email AAG Riggs and we'll see we get on the same page, and I'm sure we'll get it accomplished.
All right. Okay, so we will, I'm sorry, is there anything other than that that we need to discuss today?
That's it on behalf of the people, Judge.
All right, so then I'll sign. Yeah, go ahead.
If it helps everybody, I get back from Oakland County in about a couple hours. I can prepare stipulations and orders for both of them to save everybody time and get them to your office by this afternoon.
Okay, that would be great.
No problem.
All right. Thank you all for your time then. Mr. Sepulveda, you can let the officer that's with you know that you're done with court for today.
Yes, Your Honor. Thank you.
Thank you.
Have a good day, Judge. Thank you. Bye.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Mr. Glazier, are you ready to proceed with Ms. Scholes?
Yes, I am, Your Honor.
Okay, we are on the record then in file 23-21524-FH, People versus Allison K. Scholes. We are here today for a pretrial in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
B.V. McClure on behalf of the people.
John Glazier on behalf of Ms. Schultz.
All right, and let's see. Ms. Scholes, are you there?
Yeah, I'm here. I'm breastfeeding my baby, so I have my phone tilted up.
Okay, that's fine. Just need to confirm that you're there. So, Mr. Glazier, where do we stand with Ms. Scholes' case today?
Your Honor, Ms. Scholes is proceeding through the Economic Crime Unit program. She's been in touch with Mr. Went, and it's a situation where she knows, well, they're still figuring out how much she has to pay, but she'll have enough from her tax returns to pay that off and any other associated costs. So we'd ask to adjourn this maybe 90 days so that she can get her tax return.
All right, Ms. McClure.
No objection, Judge.
All right, so 90 days would take us to first part of July. So best I can do looks like it's July 17th at 8:15 a.m.
That'd be fine, Your Honor.
Okay, and Mr. Glazier, can your office do the stip and order?
Yes, I can, Your Honor.
All right, so
you can sign my name with permission to that.
All right.
Okay, and so Ms. Scholes, your next date is going to be July 17th at 8:15 a.m. You'll log in with all the same Zoom information that you used to log in today.
Okay, thank you, Your Honor.
Great, thank you. Go ahead and log out.
Okay.
And then Mr. Glazier, I believe this is Mr. Blass at the Zooming from the jail. Do you need a breakout session with him?
Yes, Your Honor.
Okay, Ms. Underwood, I do not have Mr. Moreno here. I don't know if you've tried contacting him or want to try to contact him.
He failed to appear last time too, Judge.
Your Honor, I have tried to contact Mr. Moreno. The situation we're in is, I've tried to contact him both by phone and email.
Okay, right. Ms. Underwood, let me call the case then, so we don't have to do it twice.
Thank you.
Okay, we are on the record in file 24-21714-FH People versus Jesus Joseph Moreno. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Good morning, Your Honor. Rod Underwood for Mr. Moreno this morning.
All right.
I was saying.
The record should reflect that this was set for 8:15 a.m. this morning. Mr. Moreno has not appeared. He's not in the Zoom session and he's not present here in the courtroom. It's now 8:52 a.m. So, Ms. Underwood, if there's something you'd like to say about Mr. Moreno's presence, you can go ahead.
Briefly, Your Honor. We have been unable to get in touch with him. However, there is a recent income withholding and there is money coming in, which I believe, does say something. I'm not sure what the problem is, but I would ask that if the court is going to issue a bench warrant, they give a grace period, Your Honor, so we can again try to, we've tried, but so we can again, hopefully Mr. Moreno will contact us.
And Your Honor, the defendant posted a large bond in this matter. He is working. I do see an income withholding order that just started at the end of March. However, he failed to appear March 13th, and I didn't request a bench warrant. We gave him time because of those circumstances for counsel to get in touch with him. So I am going to request a bench warrant today. If counsel can get in touch with him and arrange for him to come and turn himself in, and he's still making payments, then of course I'll agree to set aside the bench warrant. But I think that I need to request it at this point since it's 2 times he's failed to appear.
All right, I would agree with Ms. Brenner. This is the second time he's failed to appear and is not apparently responding to attempts to contact him. And so what I'll do is, although he's not entitled to it, I will wait the 48 hours to give him one last chance, since at least we're getting some payments from him, but I can't continue to just not have him show up. So I'll wait the 48 hours. If we haven't heard from Mr. Moreno within that time, I'm going to revoke and forfeit his bond at that time and issue a bench warrant. I would set bond on that bench warrant in the amount of $5,000 cash or surety.
Thank you very much, Your Honor.
And Your Honor, do I prepare the bench warrant or does your court? I forget.
For a failure to appear, I think we do that.
Okay. Okay, thank you, Judge.
So I think we're all set on that one. Mr. Glazer, are you ready to proceed with Mr. Blass?
I am, Your Honor. I don't know if Phoebe has sent the amended information yet or not.
I have prepared one, but I was waiting to send it until I knew if we're gonna enter a plea today or not.
Yeah, I talked to Mr. Blass, and I think we're going to take care of it today, Your Honor.
So I will forward it to everyone right now.
All right. Are you sending mine to my email?
I was gonna send it to yours and the PDO email.
My personal one or the county one?
Whatever one I haven't, I don't know.
Okay, I'll have Leo check.
Okay, sorry. It's not sending it to Francis. And John, do you want me to put the offer on the record now? So we're clear. You're muted, I think.
Yeah, we can do that.
Okay. Judge, did you call the case? I'm sorry.
I don't think I did, so let me do that.
Okay.
This is file 24-21771-FC. People versus Andrew Aaron Glass. We're here today for an arraignment in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
Ema for on behalf of the people.
John Glazier on behalf of Mr. Glass. Thanks.
All right, and it's my understanding from a discussion we've had off the record that the parties have reached a resolution of this matter. Is that correct?
I believe so.
That's correct, Your Honor.
All right, so Ms. Muir, do you want to state what the offer is, and then we'll confirm that that's what they're accepting.
So at this time, the offer is to plead to added counts 4 and 5 on the amended information. That would be 2 counts of criminal sexual conduct, 2nd degree, person under 13. And as for a Killebrew agreement, I had calculated the guidelines on the CSC second at 43 to 86, but that I would Killebrew to the high end of a sentence at the high end of the guidelines. And I indicated to Mr. Glazier the guidelines on a CSC third, which was my initial offer, was 78 to 130 months. So that my offer in this case would be to start at 78 months with the plea to the second.
I thought it was a 5-year that we agreed to.
I said I would Killebrew to the guidelines of the third if he pled to the second.
Right.
It's within the second guidelines, but the guidelines would be, or my Killebrew would be starting at 78 months.
Yeah, that's higher than what we thought. Yeah, maybe we should adjourn it out. You have your notes on it, because what I have down is you told me we'd Killebrew to a 5 to 15.
Okay, yeah, I'm reading my notes right now, and that's
okay.
Exactly what I have written down.
All right.
I said Killebrew to the sentence on the third guidelines, which is 78 to 130.
All right, Judge, I think what we'll do is we'll waive waive the reading of the information down to see that, and ask that the matter be set for a pretrial. This is different than what I've told my client.
Okay. All right, so I will then enter a not guilty plea for Mr. Glass, and we'll set a pretrial in this case. I'm sorry, Mr. Glazer, did you say how far out you wanted to go?
Probably 2 or 3 weeks.
How about April 24th? That's 2 weeks from today at 8:15. That's 3 weeks from today. How about April 17th? That'd be 2 weeks from today.
April, what did you say?
17th.
17th? Yeah, that's fine, Your Honor.
So April 17th at 8:15 a.m.
Okay.
All right. Anything else we need to address with this case today?
No, that's it, Your Honor.
All right, Mr. Glass, you can let the officer that's with you know that you are done with court for today.
All right. Thank you.
Thank you.
All right. Thank you, Your Honor.
Says he doesn't show up for it, so he's not gonna show up for it. Tamara's had it, see her. Fine.
All right, Ms. Underwood, we have Alejandro Madrid here. Do you need a breakout session with him? Ms. Underwood, are you there?
Sorry, yes, yes, Your Honor, sorry.
Do you need a breakout session with
Yes,
Mr.
thank
Madrid?
you.
I have someone here logged in. Your screen name is Karina Butcher. Can you tell me what case you're here for? I have a person logged in whose screen name is Karina Butcher. Can you tell me what case you are here for? You'll see if you can find that Smith file. We are on the record in file 23-21441-FH People versus Alejandro Luis Madrid. We are here today for a hearing on a probation violation. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Madrid, Your Honor.
All right. And where do we stand with Mr. Madrid's case?
Your Honor, I believe Mr. Madrid wishes to enter a plea on the violation?
Mr. Madrid, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
You are Alejandro Luis Madrid.
Yes, sir.
Mr. Madrid, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You have a right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes, sir.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand that?
Yes.
On the other hand, you understand that you have a right to testify at your trial if you wanted to testify.
Yes.
How do you plead to the charge that you violated your probation by leaving Dawn Farms Residential Treatment Program on or about February 12, 2024 against staff advice?
Guilty.
And how do you plead to the charge that you violated the terms of your probation by providing a false address to your probation officer?
Your Honor, that mixes in it with the same charge, right? Like, because I left probation, that's the, like, is that mixed in together or is that separate?
So they're separate allegations.
Okay. Because Your Honor, I gave Tom Moore my real address.
Your Honor, I apologize. Could I speak to Mr. Madrid in a breakout, please?
All right. Okay, the gentleman that just got your audio connected, can you tell me your name?
Jesus Marino.
All right, Mr. Moreno, we already called your case today. You're about an hour late. So I'm gonna put you in the breakout. I'll put you back in the waiting room. Stay there until your attorney gets back here and is ready to speak to you.
Okay.
Yeah. Okay, we are on the back on the record in People versus Alejandro Madrid. Ms. Underwood, where do we stand with Mr. Madrid's case at this point?
My apologies, Your Honor. Something has come up and I'm going to ask that this matter be adjourned briefly. Mr. Madrid does have another case in district court that I thought had been taken care of, but it has not. So I am going to ask that this be put out to perhaps the 10th, Your Honor.
All right, so I'll adjourn to April 10 at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. Madrid, you can let the officer that's with you know that you're done with court for today. So we can do Michael Madrid and Hezekiah.
Your Honor, has Mr. Moreno by any chance zoomed in?
He has. Do you need a breakout session with him?
Yeah, just briefly.
All right, we're trying to get a hold of Ms. Brenner to log back in.
She may be in the other courtroom.
Can you hear me?
Yes.
Hello, it's Kelly and Judge Hosick. Could we have Hezekiah Hall in one room and Michael Madrid?
Ms. Hennigan, could you approach?
Thank you.
Oh, see, officer. All right, we are back on the record in file 24-21714-FH People versus Jesus Joseph Moreno. We were previously on the record in this case, and Mr. Moreno had not appeared, so the court stated its intention to issue a bench warrant if Mr. Moreno did not appear within 48 hours. He has now appeared. So, Ms. Underwood, where do we stand at this point?
Your Honor, Mr. Moreno is here, and I would humbly request that the court quash the bench warrant. And Your Honor, based on our conversation before with Ms. Brenner, I believe a 45-day adjournment to monitor payments would be appropriate in this matter, Your Honor. I would be happy to do the stipend adjournment with Ms. Brenner's permission.
And Your Honor, he has started making payments. He posted the 25% cash bond. I am willing to offer the delay of sentence plea that I do offer in some of these cases. If he would like more time to continue to make payments, I don't have an objection to that. So just so he knows, I need to see him paying as ordered at a minimum, and then we can enter that delay of sentence plea to give him additional time to earn a reduction of the charge. But I do not have an objection if the court wants to grant him more time. And I do not have an objection to Ms. Underwood preparing that.
All right, so let's set it for May 22nd at 8:15 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Moreno, you need to log back in on May 22nd at 8:15 a.m. You'll use all the same Zoom information that you used to log in today.
Yes, sir.
Thank you, Your Honor.
And go ahead and log out.
Thank you, Judge.
Thank you.
Judge, what date was that?
May 22nd.
I have that you are doing arraignments only on that. I apologize.
All right, I'll get it figured out. All right, Mr. Murphy, we have Mr. Hall here. Do you need a breakout session with him?
Please, Your Honor, if I could.
Mr. Malero, we have Damian Adams. Does he happen to be at your office with you?
Judge, I thought we waived his arraignment.
Okay, yep, you did. I'm sorry, I missed that.
Ooh, scaring me, Judge. I do have a Michael Madrid, though.
Yeah, we have called the jail for him. We're just waiting for them to put him in one of the pods.
Okay, I'll wait. Thank you.
Fat Mexican, fat sumo looking fat motherfucker.
All right. First of all, Mr. Madrid, you're in a courtroom now, so you need to mind your language.
I'm sorry. Usually when I come in, it's not on. I apologize.
Mr. Malero, do you need a breakout session with Mr. Madrid?
Yes, I do, Your Honor.
All right, 1 second.
Your Honor.
Yeah.
Do you have like Jackson Elliott in the courtroom?
I do not.
I
You
wonder,
want some time to contact him or?
well, I can. I did try to contact him. I was unsuccessful, and I wonder if we could call the case.
Okay, we are on the record in file 24-21730-FH, People versus Jackson Joel Elliott. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure on behalf of the people.
Your Honor, Michael Dagger Margosian for Mr. Elliott.
Okay, and this matter was set for pretrial conference this morning at 8:15. It is 9:24, and Mr. Elliott has not logged into the Zoom session and is not present here in the courtroom. Mr. Dagger Margosian, is there anything you'd like to say with respect to that issue?
Yes, Your Honor. I did reach out to Mr. Elliott. I was unsuccessful in contacting him. What I will say is that this case was waived. The exam was waived to circuit court with the intention of entering a plea under HIDA. Mr. Elliott is 19 years old. He has no from what I can tell from my chat, he has no convictions of any kind. He was very responsive and present in this case leading up to today. I don't know where he is. I don't suspect that it's some intentional thing he's not here. I think this is the first court date in circuit court, and with all of that being said, I think I would ask the court if the prosecutor doesn't have any objections to this, to not issue a bench warrant at this time and maybe issue a show cause and see if we can get Mr. Elliott here to court.
Okay, Ms. McClure, anything you want to address with respect to that issue?
I don't have anything to add. I would leave it in the discretion of the court.
All right, I do have, let me just check. There is one person that is a name not associated with any case that I have on the docket this morning, so see if I can figure out who that person is. So have someone here log.
I'm actually getting a call from the number that I believe is Mr. Elliott. If I can just take this.
Yeah, go ahead.
Thank you.
Okay, have someone here logged in under the screen name Karina Butcher. Can you tell me your name, please, and what case you're here for? Okay, Mr.
He should be logging on now. He said he's been trying to log on. So I gave him the Zoom number again. So hopefully we should see him soon.
You hear me?
All right, I believe we have Mr. Elliott here now. Sir, you're Jackson Elliott?
Yes.
All right, so then Mr. Dagger Margosian, where do we stand with Mr. Elliott's case?
Your Honor, we are in a position to resolve this matter. As indicated, we waived the preliminary exam to take a plea in circuit court. The plea will be that Mr. Elliott is pleading guilty to felonious assault under HIDA, and further, there's a sentencing agreement for no upfront jail.
All right, I'm going to need an amended information for that plea.
Just take me just a minute to get that done.
All right, Mr. Elliott, I'm going to put you back in the waiting room until we're ready to come back to your case. So just hang tight till we get back to you.
Yes, sir.
Okay, Mr. Murphy, are you ready to proceed with Mr. Hall?
I believe so, Your Honor.
Okay, we are on the record in file 24-21756-FH, People versus Hezekiah William Hall. We're here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Matthew Murphy, appearing on behalf of Mr. Hall.
And Mr. Murphy, where do we stand with Mr. Hall's case today?
Yes, Your Honor. At this time, I believe that we have a plea agreement worked out with Mr. McCready and myself, and Mr. Hall would plead to count 1, possession of methamphetamine, without the second offense notice. The remainder of the file or the case would be the remainder of the counts would be dismissed. There will be an agreement for that charge to be ran concurrent with what Mr. Hall is currently being sentenced for tomorrow in front of Your Honor. So I don't know if the court needs an amended information or not, because it is to count 1 just without the second offense notice. And again, if I'm incorrect, I would ask Mr. McCready to correct me at this point.
No, that is correct, Your Honor.
All right, Mr. Hall, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
You are Hezekiah William Hall?
Yes, Your Honor.
Mr. Hall, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of methamphetamine?
Yes, Your Honor.
You understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice he's given you?
No.
I apologize. Mr. Hall, are you satisfied with Mr. Murphy and the advice he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. McCready?
Other than what's been stated on the record, that is correct.
Thank you. I apologize. Is that accurate, Mr. Murphy?
Yes, Your Honor.
Is that also your understanding, Mr. Hall?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. It means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Hall, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a...
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about January 18, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of possession of methamphetamine or ecstasy?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
Other than we would run everything concurrent.
All right. But other than that, no one's made any threats or promises to you. Is that correct?
Correct.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than plea bargain to induce Mr. Hall to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Hall, has your attorney promised you any particular sentence or estimated what your sentence would be, other than as we've discussed it on the record here this morning?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Mr. Hall, were you indeed in the city of Adrian, the county of Lenawee, the state of Michigan on January 18th, 2024?
Yes, sir.
And on that date, did you have in your possession some methamphetamine?
Yes, sir.
Did you know that it was methamphetamine?
Yes, sir.
Okay, and did you have any prescription or any legal reason to possess that methamphetamine?
No, sir.
Your Honor, I believe we covered the factual basis.
People are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Murphy?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Hall has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here this morning. I will refer this matter to the probation department for a pre-sentence investigation.
Your Honor, I did want to inform the court again, Mr. Hall is up for sentencing tomorrow on a previous file. Obviously, that's really short notice. I don't know. I mean, looking at the PSI for that, this obviously was known about a pending charge. So I don't know if a new PSI needs to be performed for this file, or if we can tack this on with sentencing tomorrow. Again, if there's no necessity for it, that's what I would ask for.
I would defer to Ms. Walsh, but I would assume that they have to go through their process for each file, and so.
Yes.
That's correct. Would need extra time for that.
Right, thank you.
Can somebody give me the file number for tomorrow's sentence so we have that?
Yeah, there's 2 files, 2321592FH and 2321593FH.
The second one was 2321593. Okay,
Yeah.
thank you.
Okay, so let's set this file for May 10th at 8:15 a.m.
Yes, Your Honor, thank you.
And will we then adjourn tomorrow's sentencing and have it follow this case?
I defer to Mr. Murphy if you want to do that. That'd be fine, and just do everything on May 10th, or we can.
I mean, I guess, Mr. Hall, would you prefer to have sentencing done tomorrow on the other case and then come back again on the 10th of May, or we want to just come back on the 10th of May?
You just come back on the 10th of May if that's what you would rather do.
I mean, I think that would be the best. I know Mr. Hall would like to be in person for sentencing.
Okay. All right, so we'll adjourn tomorrow's sentencing to May 10th at 8:15 a.m. and that will be in person.
Thank you, Your Honor.
Thank you.
All right, so Mr. Hall, you can let the officer with you know that you are done with court for today.
All right, thank you.
Thank you, Mr. Hall.
Yep.
All right, Mr. Malero, you ready to proceed with Mr. Madrid?
I am,
Excuse
Your
me.
Honor.
All right. Okay, we're on the record then in file 24-21750-FH, 22-20968-FH, 22-20969-FH, and 22-20972-FH. People versus Michael Anthony Madrid. The 24 case is set for pretrial hearing. The 22 cases are set for hearings on alleged contempts. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Salvatore Malero on behalf of Michael Madrid.
All right, and Mr. Madrid is present by Zoom from the Lenawee County Jail. Mr. Malero, where do we stand with Mr. Madrid's cases today?
Your Honor, there's some violations of probation, which were recently assigned to me, and then there's the pretrial. I'd ask for perhaps a 2-week short continuance, adjournment, so that I could perhaps get these matters resolved if we can. And then I think 2 weeks should be sufficient for myself and Mr. McCready to hook up and get something resolved if it's possible. That is my request.
I have no objection to that.
So 2 weeks would take us to April 17th. I can set it for April 17th at 8:15.
That is fine, Judge.
That's fine.
All right, Mr. Malero, would you prepare stipulation and orders for those adjournments?
I will, Judge.
Okay, Mr. Madrid, you can let the officer that is with you know that you are done with court for today.
Thank you, sir.
Thank you, Your Honor.
Okay, Ms. Hennigan, I believe we have Ms. Kneisel now from the Friend of the Court. All right, we are on the record in file 21-48237-DM. Justin Smith versus Sarah Ann Smith. We are here today for a hearing on a Friend of the Court show cause. We're representing today in person. Sir, you're Justin Smith?
Yes, sir.
All right, Ms. Hennigan, you want to place your appearance on the record?
Thank you, Your Honor. So Mayor Hennigan appearing on behalf of Sarah Smith, and Sarah Smith is sitting here to my left.
All right, it looks like there were previous hearings on this alleged contempt before Judge Saul. Is that accurate?
That would be accurate, Your Honor. I believe this case has recently been reassigned to you.
All right, so Ms. Smith has been arraigned on the alleged contempt then, and so Ms. Hennigan, where do we stand with respect to this case today?
Your Honor, it's my understanding that my client has provided several documents to Ms. Pelham, who is usually her worker. She was injured at work February 2023 and has been off work since that time. She had an evaluation to determine whether or not she could return to work, and has also provided that documentation to Ms. Pelham. Currently, She has been advised by her medical team that while she could return to work, she would have restrictions on lifting, bending, standing, and sitting for prolonged periods of time. She has applied for several positions on Indeed, however, has been unable to secure anything that would meet those restrictions. So it is quite the obstacle for her to find employment right now, considering the medical restrictions that she currently has. And she does not have an anticipated date of when she might be able to return to work if she's still receiving therapy and other medical services for her injury.
All right, so I'm going to presume that Ms. Kneisel, since she's filling in for Ms. Pelham, probably has not had an opportunity to review that information, or have you, Ms. Kneisel?
I have not, but we do have an order from Judge Sala prior to this that she was to petition for a review of the support, which she has done. And that review is set to take place on 4/23.
All right, what I'm going to do is adjourn this to April 29th at 8 a.m. At that point, we will hopefully know the result of the petition to modify. And by that point, Ms. Pelham will be back and have an opportunity to view the documents that have been provided by Ms. Smith, and I'll have a much better picture of where things stand at that point.
Thank you, Your Honor. Could you confirm that time for me?
April 29th at 8 a.m.
Thank you very much.
Great.
Thank you, Your Honor.
All right, so we're all set for today.
Thank you.
And you can do that by Zoom if you prefer, Ms. Henry.
Thank you, Your Honor.
Okay, Mr. Dagger-Mangosian, I have the amended information for Mr. Elliott now. Do not see Ms. McClure, though. I don't have any prosecutors at the moment, so we're going to need to. Oh, there you are.
Sorry, Judge, I was finishing up a phone call.
Okay. All right, so we are back on the record then in People versus Jackson Joel Elliott. I do now have an amended information with an added count 2, assault with a dangerous weapon or felonious assault. Are we ready to enter the plea then?
Yes, Your Honor.
Mr. Elliott, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Jackson Joel Elliott?
Yes, sir.
Mr. Elliott, you've heard the statement of your attorney and the prosecuting attorneys that your intention to plead guilty today to count 2, assault with a dangerous weapon, also known as felonious assault.
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes, sir.
Are you satisfied with Mr. Dagger-Mangosian and the advice that he's given?
Yes, sir.
Other than as we've discussed on the record today, neither the prosecutor or defendant or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
We do have a plea agreement. Was that placed on the record?
Yeah, I believe that was all placed on the record earlier when we were on the record.
Then yes, nothing else.
Mr. Daggerman.
Nothing further, Your Honor.
All right, Mr. Elliott, if a plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Elliott, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir, I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about January 20th, 2024 in the city of Adrian, County of Lenawee, that you did commit the offense of assault with a dangerous weapon?
I plead guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
One more time.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir.
Prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Elliott to plead guilty?
None, Your Honor.
No.
Mr. Elliott, other than as we've discussed on the record this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
I was told less or 2 years or less than height of probation.
All right, I believe that was consistent with the plea agreement.
It is, Judge, the length of time Mr. Elliott is referring to is just my estimate on what the length of probation would be under HIDA.
Okay. So, Mr. Elliott, do you understand there's an agreement that you would receive probation under HIDA, or the Homes Youthful Trainee Act? The period of probation was an estimation and not necessarily what it will be. Do you understand that?
Yeah, I knew the period was an estimation.
Okay. And you still want to move forward?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Dagger-Bogosian, do you want to cover the factual basis?
Mr. Elliott, on January 20th, 2024, were you in the city of Adrian, County of Lenawee?
Yes, I was.
And on that date, did you have an interaction with Joshua Butcher?
Yeah, I did.
Did you assault him on that date?
Yeah.
And was this done when you had a weapon in your possession?
Yes.
And was that weapon a knife?
Yeah.
Okay. And he didn't, of course, consent to any assaultive conduct on your part?
I guess not, no.
Okay. I'm satisfied, Judge.
Ms. McClure?
Mr. Butcher, or excuse me, Mr. Elliott, did you actually make contact with Mr. Butcher with that knife?
Yeah.
And he had to receive medical attention as a result of that?
I believe so.
Okay, satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Yes, Your Honor.
Mr. Van- Okay. I will accept the plea then. It's been understandably, voluntarily, and accurately. Mr. Elliott has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement other than as we've discussed on the record this morning regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for May 10th at 8:15 a.m. Mr. Elliott, you will need to report to probation for a pre-sentence investigation interview. I'm going to place you in a breakout session with Ms. Walsh from the probation department for her to collect your information and give you some instructions on what you need to do with them. When you do your interview, please be truthful about this offense and about your background.
Yes, sir. Judge,
Yeah.
the date you said, do I have to appear to that? The May.
You need to be here either by Zoom again or in person. It's your choice.
Okay, on that date, May 10th, 8:30?
8:15.
8:15?
Correct.
Okay.
All right, Mr. Dagger Margosian, did you want to be in that Zoom room with Ms. Walsh as well?
Just briefly, and then I can exit.
Sure. Okay.
Judge, did you already handle Michael Davis or Raymond Glaze?
I have not done either of those.
Okay.
Oh, Kelly is telling me that those were both adjourned.
Oh, okay. Then I think that's all you would need me for this morning.
Let me. Let me just run through everything real quick. Davis, you said it's adjourned.
Davis adjourned.
Glaze was adjourned.
Glaze was adjourned.
Yeah, I think we're all set then.
Okay, thank you.
Thanks. So
Oh, it's Kelly, your judges, nurse. Could we have Mark Silvertooth in the room for the judge, please? Thank you. Bye.
Really, it's fun. Yeah, I would you mind jail to see if that Randy part is over there. I think I remember her saying something yesterday about him.
It's not on the jail list. Was.
Yeah, it's like- Okay, you can go ahead and log out then, Mr. Elliott. You're all set.
All right, have a good day.
Thanks.
Thank you very much. He's
We are on the record in file 23-51040-PP, Brittany Lynn Brewster versus Brandon Charles Farnell. We are here today for a hearing on an order to show cause relative to an alleged violation of personal protection order. I do not, in reviewing the file, see a proof of service indicating that the order to show cause was served on Mr. Farnell. Record should reflect this was set for 8:15 this morning. Neither Ms. Brewster nor Mr. Farnell are at this point. Again, I don't have any proof of service indicating this was that the order to show cause was served on Mr. Farnell. And so I don't believe there's anything I can do to proceed with this matter, not knowing whether or not he has been served. I will at this point leave the show cause pending, and if Ms. Brewster wishes to proceed with it, we need to have her serve Mr. Farnell with an updated notice of hearing.
So I don't know what they're gonna do. I'll take that. Take that. Get 2 sheets. Blanket.
The young versus you. We are on the record in file 23-50408-PP, Andrea Young versus Jason Young. We are here today for a hearing on an order to show cause. Record should reflect this was set for 8:15 this morning. It is now 10:02. Neither Ms. Young nor Mr. Young are present here in person or by Zoom. In the file, I do not see a proof of service indicating that the order to show cause was served on Mr. Young. I am aware that they do have a hearing on Mr. Young's motion to terminate the personal protection order next week on April 10th. So at this point, there's nothing further that I can do in the absence of proof of service. So perhaps address the issue with them on April 10th.
It got added on to back in the 80s.
Come over here on this side. Not sure how it works. Yeah, not sure how it works. There we go. Huh?
Finally, the day came.
Random getting out down here.
Yeah, yeah, you got, I don't know. Put those and bring them down. Bye, Miss Carr.
Bye, thank you.
Told me we're nice.
Anything else?
Nope.
Thanks, guys.
Pretty
All right,
good.
thank you.
Pretty good, thank you.
Scar, keep that up. I am ready. Okay.
Indiana, no. All right.
I think we're all set. I just gotta get sober to you.
Oh, you said that. Bring her.
Dollar.
Oh, dollar.
I'll take $84. Over to you. Got you some new glasses? Yeah, last time you were all taped up. Yeah.
Oh.
All right, we are on the record in file 1-20410-FH, People versus Mark Anthony Silvertooth. We are here today for arraignment on a warrant for probation violation. Sir, you are Mark Anthony Silvertooth?
Yes, sir.
Mr. Silvertooth, have you received a copy of the warrant?
Yes, sir.
The
Yes, sir.
warrant alleges that you violated the terms of your probation by being in possession of cocaine and by failing to notify the probation officer of police contact. You had previously pled guilty in this case to one count of malicious destruction of property, $200 or more, but less than $1,000. Maximum penalty for that offense is up to 1 year in jail. You'd also pled guilty to third-degree home invasion with a habitual offender first offense. And the maximum penalty for that offense would be up to 7.5 years in prison. Do you understand that, sir?
Yes, sir.
You are entitled to be represented by an attorney here today and at any other proceeding we have in this matter. If you can't afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, sir.
Would you like to be represented by an attorney?
I need one. I don't have I can't afford an attorney.
Okay, I will have you speak with someone from the public defender's office. We will try to get in touch with them right now to have someone log back in.
Okay.
Judge, I'm here.
Oh, I'm sorry, Mr. Malero, I didn't know you were still here. So I'll put you in a breakout session with Mr. Malero.
Who am I talking to, Judge?
This is Mark Silvertooth.
Oh, yeah. All right, I think I have him anyway, so, okay.
Okay, and so we will get you a copy of that warrant as quickly as we can.
All right, thank you, Judge.
Okay, I apologize, Mr. Malero. I clicked the wrong button, so let me try this again. Okay, we have Mr. Malero and Mr. Silvertooth back from the breakout session. Mr. Malero, do you know how Mr. Silvertooth would like to proceed?
Yes, Your Honor. From a brief review, it looks like the violation of probation is related to the new charges Mr. Silvertooth has pending down at district court. I would ask, it says there's no bond set on this matter. It said the allegation is that he didn't notify the police of police contact and that he was in possession of cocaine. We would stand mute as to those allegations at this point. There's no other allegations of him not reporting or other non-compliance, Judge. So I'd ask if the court would set bond at $500 cash or surety. He lives in Adrian. He's on disability. There's no indication he's a flight risk and or in danger to the community at large. So that would be the basis for our request on the bond, Judge. He does have a bond hearing on the pending felony Friday.
Judge, this offense was from July. And although he was raided and didn't report the police contact, he's had a couple issues since then that we've already taken care of. I'm actually not opposed to a PR bond for him. He has a $10,000 cash surety bond on the new felony at this point downstairs.
Okay. If that's the case, then I will do a PR bond for Mr. Silvertooth, unless, Mr. Malero, do you want me to do something small in case the bond situation doesn't work out downstairs?
Well, how can I say no to a PR bond, Judge?
Okay. If we need to make any change so that he gets credit if he doesn't get released on the district court charges, we can do that. So so I'll issue a PR bond at this time for Mr. Silvertooth, and we will set this out. About April 24th, is that a sufficient amount of time, Mr. Malero, to figure out where things are going downstairs?
Yeah, I think that's sufficient, Judge.
Let's go with April 24th at 8:15 a.m. Ms. Walsh, do you want Mr. Silvertooth to report to you upon release?
He can call me as soon as he's released.
Okay, so Mr. Silvertooth, you'll need to call Ms. Walsh as soon as you get released.
Okay. Yes, sir.
All right. Anything else that we need to address for today?
Mr. Silvertooth, I forgot to call.
Yes.
I forgot to call Cammy yesterday.
Okay.
You still want me to call her?
Yeah, you can. She probably know now.
Okay.
I'm pretty sure she know that.
Sorry.
Thank you. All right.
All right, I think we're all set for today then. Mr. Silvertooth, you can let the officer with you know that you're done with our court for today.
I'm sorry, Judge. What is the date? Our next date? April
24.
April 24th.
Okay, thank you.
Yep, thank you.
All right. Thanks, John.
Thank you, Your Honor. Thank you, Ms. Walsh.
Thank you,
welcome.
Mr. Malero.
Thank you, sir.